do we hit go live here? Yeah, there we go. Let's see. Okay, hello everyone. It's me, lcadilac. Good afternoon. It's afternoon already in Texas, so I'm glad to see y'all here. Already have 12 people. So excited all of you are here. Today has been an interesting day of court, hasn't it? Oh, y'all, I got my fans on back here. I hope these aren't affecting your sound. If the fans are bothering me, let me know. We're bothering you. But it's at least 5 degrees hotter in my office than it is next door. I am lcadilac, and I am an attorney in Dallas, Texas. I am a litigation attorney. That means that I work in courtrooms. I have a civil practice. I focus mainly on real estate and real estate related work. I do property tax protests. I do quiet title lawsuits, lots of that stuff. I have tons and tons of videos about Texas real estate. So if you guys are interested, just look around this YouTube channel. I began watching this Young Thug trial mainly because I was interested in the First Amendment rights issues and the idea of using lyrics against someone, in using art as speech against someone really intrigued me. And of course, I started watching it and I have become hooked with the absolute train wreck that this trial has become. So I stream every Friday morning at 10 o'clock Central, 10 a.m. Central, a recap of the week. And since today they were having kind of a modified court day and we got some really interesting recusal motions filed, I decided we should get together and go over them. So if y'all have been watching this morning, currently the court is on a break. There is some sort of evidence that is being redacted, both by the state and the defense. And I guess the judge is going to review the redacted versions and then make a ruling. That's my understanding of what's going on this morning. So they're on a break. The judge just said he'd be back in an hour, because they're an hour ahead of us. So he said he'd be back at 2:16. It's 2:15. It's 1:15 there. So he'll be back in an hour. I'm glad everyone's saying the sound is good. I appreciate it. I downloaded an app for the mic and I pushed a button, and I think things should be better than they've been in the past. So every day is a learning experience, y'all, and y'all are growing with me, and I appreciate you so much. So I want to say thank you first to all of my members. I have almost 50 members. It is so exciting. I cannot wait to tell my children that I have there's no doubt, evidence proves I have at least 50 fans. That is so exciting. Y'all have helped me become a real hero to them, that I'm a real live streamer, and I appreciate it so much. I want to thank everyone who has hit like, everyone who's subscribed, and everyone who chats. I have the best chat in the entire internet, okay? I have the best chat in the whole internet, so thank you for being here. All right. Now, I was going to talk today about impeachment because Miss Hilton and her impeachment efforts this week have been interesting. But I'm going to in fact, focus on these motions that were filed, the recusal motions, because they're so interesting. And we will definitely do impeachment. The next time there's a lag or a break in trial, I will do a bonus of impeachment. Okay? So, thank you everyone that's here, and let's get it started. All right. Now, I think I'm going to say unknown to a lot of us, Miss Kayla Bumpkis hired some counsel, and her counsel filed a motion to quash order to show cause and motion to recuse this court. She filed it at 10 p.m. on the 14th of June. Now, as I recall, the 14th of June was Friday. So that's 10 o'clock Friday it was filed. I know for a fact that by 4:59 p.m. on Monday, the 17th, YSL Steel had read Bumpkis's motion because he quoted it in his motion to disqualify, recuse Glenville from all further dealings in the above referenced case and motion for mistrial, which was goaded by the improper conduct committed in concert by the court and prosecution. I mean, that is quite the title. Britt Cherie, we will have a link on how to become a member. I would love if you became my 50th member. That'd be awesome. So hang tight. We'll get that to you. Thank you, Jeremy. I wear pigtails at night when I sleep. And this morning they were feeling good. So I said, let me keep them. Also, it's 800 million degrees in Dallas, Texas. And I'm not even exaggerating. Like, it is literally 800 million degrees. So I can't properly deal with all this hair on my head. So thank you. Thank you, Tanisha. I'm glad you love the channel. Make sure y'all are hitting like and subscribe. I saw so many of my OGs. I saw Nomenclature, welcome. Unpopular Opinion, welcome. Danae, Kay, Ann, I'm Her, got a new name, welcome. Tamika, Amber, Ron, Jaime, hello everyone. Ms. Perfect, hello. Danny, hi, good to see you. Dee, hello, good afternoon. I'm so glad to see all of you. Julie, Red Bunny. I don't want to miss anyone. Y'all are the best. Cashapp, good afternoon. Andrea, Leaf Queen, Christopher. All right, K-Way, hello. B, Billy, hello. Jay, hello. Oh, your favorite lawyer. I'm sure you know a lot of lawyers in Texas, huh, Jay? Thank you. Britshire, the link is in there. And Kate, let's see, are you from the UK, it looks like? Larry, hi. Delilah, Demario, hello. Hi, everyone. Okay. So, I was reading Steele's motion last night, and I saw that he referred to Bumpus's motion, and so I thank goodness I have Belinda, because she's amazing. She found me Bumpus's, and I want to start with hers because it is, oh, Britshire, welcome to Paralegal. Thank you, my 50th member. Yay, thank you. Okay. Thank you, Danny. I had fun on Saturday. It was really interesting to be able to meet with Seti Nash, whose videos I had been watching as well. And he had a lovely lawyer on there named Tim. Tim seemed like a really great guy, so that was nice. It was fun. Okay, I love nothing more than y'all. If you knew how much time and energy and commitment Belinda and I put into this, you would be honored, actually. You'd be like, damn, those girls really care about us. We do. All right, so let's get into Bumpus's motion. Now, I don't know why, but my brain wants to call her Bumpkis. So if I say the wrong name, I apologize. But my brain just keeps saying Bumpkis, okay? I know y'all can read, but I'm still going to read out loud to you. I hate it when people read out loud to me because I know how to read. But sorry, guys, I'm going to torture you. All right. So obviously, not obviously. In almost every motion I've ever written or seen, you do like a facts overview. That's kind of like a way to soften the topic with the judge. This is an introduction of how we got here, kind of, so to speak, okay? So this motion is no different. We have the facts. The state immunized. They made him immune. They immunized Kenneth Copeland and called him as a witness. He refused to testify. The court held him in jail. Copeland and Kayla Bumpus were escorted to the court's chambers, and they had an ex parte meeting regarding whether or not Copeland would testify. Those present for the substantive portion of the meeting were Glenville, Copeland, Bumpus, Love, Hilton, security staff, deputies, 2 investigators from the DA's office, and a court reporter. 1, 2, 3, 4, 5, 6, 7, 8, at least 9 people in this room. At least 9 people were in this room. Okay. Jody says that Bumpus was in fact the mole. Well, we're about to get into the fact that there could be no mole. This motion is great. She clearly has some amazing lawyers working for her, because it is well written, well pled. It's really beautiful. Okay, in chambers, the court asked Copeland whether he was prepared to testify, and Copeland said that he was going to use his Fifth Amendment privilege. A conversation ensued regarding Copeland's understanding of immunity, how Copeland thought he may testify if he did not invoke, the Fifth, and certain facts of the case. So, this motion is asking Glenville to step down from the show cause and contempt of Bumpus. However, this motion also shows us quite a bit about what happened in that room. And I sure wish I knew how to highlight here. Okay. Right here it says, and certain facts of the case. So we have 2 prosecutors and a judge talking to a sworn witness about facts of the case. Okay. Copeland learned that he could be held indefinitely by the court if he refused to testify. Not just the 2 years he initially believed. Copeland then decided that he would testify. Now, I don't know about y'all, but that sounds pretty coercive. Oh, yes, you think you're only going to be held for 2 years if you don't testify, but in fact, it's going to be much, much longer than that, Mr. Copeland. You're going to be in jail for more than 2 years if you don't testify. Pretty coercive sounding. I mean, that would coerce me, that's for sure. You know, it's one thing to be prepared to go to jail for 2 years, but to go to jail indefinitely, I mean, nobody could prepare for that. Copeland then added that his testimony would be a lie. Now, we talked about in prior videos, I talked about this last week. If a witness is going to lie on the stand, we have, as attorneys, have a ethical duty to tell the judge ahead of time so the judge can act accordingly. Because if we know a witness is lying on the stand, we know the witness is creating a fraud on the court. And we're not allowed to permit that. So when Copeland adds that his testimony will be a lie, that should be time out. Go no further. Red light. The meeting ended and the parties went to the courtroom. I feel like that is a drastic abbreviation of what happened, because don't forget it was a 2-hour meeting. So that is a drastic abbreviation of what happened. All right, now this is important. We're getting into some really important stuff here. This ex parte meeting was not placed under seal. There was no protective order that directed the disclosure of these ex parte communications was prohibited. No attorney-client privilege existed, parentheses, clearly, as 2 prosecutors, 2 investigators, a judge, a court reporter, and various court staff were also present. So one way that if If y'all come in my office and you tell me privileged information in front of Boleyn, that's still privileged. Boleyn works for me. She's an extension of me in terms of attorney-client privilege. But if y'all are in my office and Boleyn's in here and Vivi, the front desk lady's in here, and Tina, my neighbor, swings by and she's in here, and now you say some information, it is not privileged. There's all these strangers that have nothing to do with this business, that have nothing to do with this law firm in the presence of that statement. It is not privileged. All of those strangers could be forced to testify. Now, Boleyn and I couldn't. Well, maybe we could because there are all those strangers, so it's no longer privileged. So we could be forced to testify about that conversation. That's why that's important. The judge started saying, well, this could be a privilege issue for Woody. No, it could not. When there are a bunch of people in a room, there is no privilege. When people can overhear what you're saying, you lose your privilege. Unless those people are, working for your lawyer. All right. The court never stated, ruled, or inferred that the meeting was meant to be confidential. Further, the content of this meeting was not secret, protected, or any way privileged. Let's go look at this footnote. If there was any privilege, such as attorney-client or work product, the privilege would be destroyed with all other parties present, particularly the court reporter. When there's a court reporter, it's public. If it's public, it can't be privileged. Okay. All right. Y'all, I loved this. When I read this one, I said, ooh, she got herself some good lawyers. I'm on page 2 and I'm loving it. Okay. All right. Later that same day, Brian Steel addressed the court to make his record of due process concerns, and the content of the meeting would not just be non-confidential, but usually would be given to defense under Gigolo and Brady. Now, we haven't done our Brady video yet, but Brady evidence is exculpatory evidence. So that's evidence that the government must give you. They have to give it to you. So this paragraph, they're saying this meeting is public and absolutely the contents of it should go to anyone who asks for it. Okay. Now, mind you, the judge is screaming that this is a private meeting and the sanctimonious, I don't remember the word, nature of the court. Bullshit. You have 853 people in your room. You got, there's at least 10 I counted out. That's not sanctimonious, that's not private. All right. During Steele's attempt to put his due process concerns on the record, the court began to focus on the identity of the source who leaked the meeting to defense counsel. Now, mind you, you can't leak something that isn't a secret. Okay? At no time did the judge ever say this is private. At no time did the judge seal the meeting. At no time did the judge make an order that said you can't talk about this. Also, Bumpus was a substitute. She has to go tell the other lawyer. She has to tell Milnick what happened because he's homeboy's real lawyer. She has to tell Milnick what happened. Even if the judge had said this is under seal, because Milnick is actually Woody's real counsel, she would have to tell him. The court ordered Attorney Steel to provide the name of the person who divulged the existence and context of the ex parte meeting. Attorney Steel refused. A brief hearing followed, and what initially appeared to be a classic civil contempt action — the attorney could purge himself of contempt if he provided the information to the judge — became a criminal contempt action. Now, if you guys recall, that's only because some lawyers came and taught the judge the difference. Court found Attorney Steel in direct criminal contempt and sentenced him to 20 days in the Fulton County Jail. Okay. On June 11th, the court entered a show cause order directing all individuals that were present for the conversation that took place in the court's chamber on the morning of June 10th, specifically Copeland, his attorney Bumpus, and, quote, all representatives of the state and court security personnel that were in attendance, to show cause as to why one or more of them should not be held in contempt for disclosing information from the ex parte conversation. No specific names were included in the order except for Copeland and Bumpus. Now, that's a really good point. That's a really good point. I read that order. And it did call Copeland and Bumpus out by their name, but it doesn't talk about Hilton and Love. It's very our team versus their team. It's very government versus private. Let's keep going. I absolutely love this motion, y'all. All right, this motion to me, it really does it for me. It does it. This motion really does it for me. Okay. All right. Argument. Here we go. The court seeks to hold in contempt the person that leaked the ex parte meeting to defense counsel. Thus, the contempt hearing will be about who informed defense counsel whether to find that person guilty of criminal contempt, and if contempt is found, the appropriate punishment. The procedures that a trial court must follow to hold a person in contempt depends upon whether the acts alleged to constitute the contempt were committed in court, parentheses, direct contempt, or out of court, parentheses, indirect contempt. Okay, so if a judge orders you to turn over some receipts and you don't, the judge says you have 7 days to hand over the receipts, and day 7 you haven't done it, that's indirect contempt because you're outside of the courtroom. But if the judge tells you need to answer this question and you refuse, that's direct contempt. Okay, so they're making that distinction there. All right, now, anytime you see a block like this is a block quote. That means they're quoting a lot of sentences. 3 or more sentences need to be in a block quote, needs to be indented, and needs to be single spaced. You're welcome, kids. That's formatting 101. Okay? An alleged, oh shit, contumacious act that may only be said to have occurred in the presence of the court, warranting summary contempt proceedings if the act was committed in open court. On the other hand, where the alleged contumacious acts were committed outside of the court's presence, the considerations justifying expedited procedures do not pertain. Thus, summary adjudication of indirect contempts is prohibited, and due process requires that a person who is tried for indirect criminal contempt is entitled to more normal adversary procedures. Among other things, he or she must be advised of charges, have a reasonable opportunity to respond to them, and be permitted to the assistance of counsel and the right to call witnesses. Now, y'all may recall Ashley Merchant was speaking about this. She said, oh, okay, Judge, if it's a criminal contempt, then Steel is owed notice, and he has a right to a trial, and he has a right to call witnesses. Okay, so we've heard this before. This is not new. The disclosing information from the ex parte conversation to members of defense counsel occurred not in open court or chambers, but at time and location the defense counsel were notified of the ex parte meeting. Not in chambers, but when they got it, okay? Further, direct contempt involves contemptuous conduct in the presence of the court, which generally results in immediate punishment. Here, the need for punishment is clearly not immediated, as demonstrated by the show cause order being set 2 weeks out from the order. The show cause hearing being set 2 weeks from the order. Okay, so the argument here is it's really obviously not a crisis because you set it 2 weeks out. If it was a crisis, you would have already heard it, right? You would have had the order and have them in. Forms of contempt are further divided into criminal and civil, and based on the nature of the punishment imposed. Civil contempt is a conditional punishment intended to coerce the contemptor to comply with the court. In contrast, criminal contempt imposes unconditional punishment for prior contempt to preserve the court's authority and to punish disobedience of its orders. The contempt alleged by this court of disclosing information from the ex parte conversation to members of the defense counsel could only be criminal contempt. Nothing can be done to purge or undo that alleged contemptuous act, and any punishment would amount to criminal contempt. So here they're explaining why it has to be criminal contempt and it's not civil. Civil doesn't apply in this case. Okay. Raynette, thank you for joining us, and thank you for defining Contumacious, stubbornly or willfully disobedient to authority. Oh, y'all, that's a great word to describe me. I can't believe I didn't know that word. Okay. As we continue. No contemptuous conduct occurred. There neither is nor was anything preventing the disclosure of this meeting to defense counsel. Boom. Mic drop. I mean, therein lies the crux of the issue. Did Bumpus have the right to tell the defense counsel? And here, absolutely. The judge hadn't issued an order. He didn't tell anyone it was private, right? He didn't say there was no court order stopping her from telling them that this conversation happened. And I would argue that she had a duty to disclose that. All right. Disclosure did not violate a court order. Again, there's no court order. She's not doing anything that she's told she couldn't do. She's not violating any rules. There's no standing order in place or trial order that bars or in any way limits defense counsel for witnesses or any other individuals present at the ex parte meeting from communicating with defense counsel for the defendants about the meeting. And the footnote says even if a protective order were in place that barred the participants in the ex parte meeting with a sworn key witness from notifying defense counsel, such an order would deprive defendants of their due process rights. Ex parte communications are presumed to have been in error. Now remember, I told you when the Supreme Court gets their hands on this, and they are able to see there is, in fact, an ex parte communication, in that ex parte communication, in fact, discussed actual facts and discussed whether or not the witness was going to testify, then the Supreme Court will be forced to call a mistrial because it's an error. And it's a reversible error. And if you're interested in knowing what that means, I did a whole video on appeals. I urge you to go watch it. Okay? I talk about error and what reversible error is. Okay? So, then they quote the rule. So they're quoting this case law. Now they quote the rule. Except as authorized by law or rule, judges shall neither initiate nor consider ex parte communication by interested parties or their attorneys concerning a pending or impeding proceeding. You're not even able to consider it. You can't even think about it. In other judicial hearings, both parties should be notified of the hearing with an opportunity to attend and voicing any objection that may be properly registered. These general requirements repeat in the Georgia Code of Judicial Conduct. Case law 4.1 of Superior Court Rule, the Code of Judicial Conduct. That's 3 laws this judge broke. Like that. To the extent that the show cause order may be subject to a general demurrer, the order cannot pass this test, assuming, as true, the allegation of disclosing information from the ex parte conversation to members of the defense counsel contemptuous conduct is not alleged. Furthermore, contempt may only be found where the attorney knows or reasonably should be aware in view of all the circumstances, especially the heat of the controversy, that he is exceeding the outermost limits of his proper role and hindering rather than facilitating the search for truth. Disclosing to defendants that their Sixth Amendment right just got shat on does not even come close to the outermost limits of the proper role of the attorney advocate. This is all footnotes, y'all. This is a whole page of footnotes. Right here, footnotes. All of it. I'm not going to read every bit of the footnotes. Okay, here we go. Disclosure of the meeting did not exceed the limits of anyone's proper role, and if anything, the disclosure facilitated the search for truth. They're not wrong. They're not wrong. They're not wrong. A judge may reasonably expect his clerks and other judges to keep what happens in chambers professionally private. However, they are under no legal duty to do so. Such an expectation of privacy does not extend to third parties not part of the court staff. So if you work for the judge and you hear the judge, having a fight with his wife in his chambers, it's expected that you're not going to go out and tell everybody, oh, judge is fighting with his wife in chambers. But if you don't work for the court and you hear the court fighting in chambers, you have an absolute right to go tell people. Holding an ex parte meeting in chambers did not impose a duty of secrecy. Informing counsel for defense of the existence and content of this chamber meeting did not violate any rule of law, trial order, or standing order, and is not basis for contempt. The show cause order failing to articulate an act of contempt should be quashed. I'm telling you guys, this is a good motion. When I read stuff like this, I get jealous. I'm like, man, I wish I wrote that well. But then sometimes I read my stuff and I do write pretty well, so I don't know. You're your own worst critic, right? So, all right, Section B. This court must transfer this contempt matter to another judge under the procedure for indirect contempt, or alternatively, recuse itself pursuant to Georgia Code or Judicial Conduct Rule 2.11. The court must transfer this matter to another judge under the procedure for indirect contempt. The court may not preside over this contempt proceeding because the court does not satisfy the following criteria. In indirect contempt actions, the trial judge who was presiding over the trial during which the alleged contumacious conduct occurred may preside over the contempt hearing if the contumacious conduct was not directed toward the judge and the judge did not react to the contumacious conduct in such a manner as to become involved in the controversy. Here, the alleged contemptuous conduct was, as expressed by the court, directed at least in part towards the court personally and the sacrosanct nature of its chambers. Remember, he kept saying that word? I had to Google it. Sacrosanct. I had never even heard of it. The court became involved in the controversy both by holding the ex parte meeting in the first place and by way of the fact that this court is a witness to the potentially disputed fact of whether there was any kind of order not to disclose the meeting to counsel for the defense. Better put, well, not better, that was really well put. More simply put, you are a witness. The court is a witness. The court is a witness. I see all of you chatting. I appreciate you so much. I'll come back to your messages when we'll go through them right after I finish this motion. The Georgia Code of Judicial Conduct Court. That's not. It must be court conduct. Dictates recusal because the court's impartiality might be reasonably questioned. When considering the issue of recusal, both OCGA Section 15-1-8 and Canon 3 of the Code of Judicial Conduct, yeah, that's right, should be applied. The Code of Judicial Conduct provides a broader rule for disqualification than does OCGA. The broad rule of disqualification set forth in the Georgia Code of Judicial Conduct provides judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned or in which the judge has personal bias or prejudice concerning a party or a party's lawyer or personal knowledge of disputed evidentiary facts concerning an impending matter or pending procedure. Okay. Now we're about to really, this is where you get it. This is how you know these are expert legal writers, okay? Just beautiful. Beautiful. Here, the court's impartiality might reasonably be questioned for 5 reasons. Y'all, they're about to list 5 reasons your ass is being reasonably questioned, YFN Glenville. All right, here we go. First, this court stated, and I quote, "This is so sacrosanct to have a conversation in my chambers parroted to you and others. It's that serious," revealing that this court views the harm to be at least in part direct harm to the court personally and or the sanctity of his own chambers. 2. As described in the show cause order, some of the other participants in the ex parte hearing were the court's own security personnel. This gives rise to 2 issues. As potential witnesses, they may testify at the hearing, at which time the presiding judge will have to assess the credibility of their testimony. It might be reasonably questioned that this court would give more credibility to the court's own security personnel than it would other potential witnesses, such as Attorney Bumpus. It's pretty logical, right? Your security detail who has been working by your side day in and day out for 10 years versus Bumpus, who came in front of you for the first time in this crazy ex parte meeting. Further, the court's own security personnel and reporter, like Bumpus, are subject to potentially being held in contempt. This court's impartiality might reasonably be questioned if it were to sit as both the prosecutor and the fact finder when deciding if it was the court's own security personnel and reporter, someone else who disclosed the meeting. So how is the judge supposed to be impartial and determine if it was Bumpus or security guard or the court reporter? You don't get to be judge and jury, or well, you don't get to be judge and prosecutor, that's for sure. Third, this court has personal knowledge of a potentially disputed evidentiary fact of whether there was an order of any kind barring disclosure of the meeting to counsel for the defense, because otherwise the disclosure is fair game. So unless the judge barred it with an order, it's fair game. Fourth, this court appears to already have decided prior to any hearing that it was Attorney Bumpus who made the disclosure. While holding Steel in contempt, the court stated, "Well, then, other than you, if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left. And if that person gave you the information or shared that information with you, she probably violated privilege." He has already made a conclusion. He has already determined who told this information, which he is very upset that it got told, but he never told anyone they couldn't tell it, so how are they supposed to psychically know? The court's show cause order reinforces this predetermination as the order references no other person preference by name than Bumpus and Copeland. I mean, come on. And fifth and finally, the court was visibly impacted when it learned that Attorney Steel had been informed of the meeting. Visibly impacted. Yeah, he was hysterical. He was hysterical. If he had been a woman, it would have been all over the news how emotional he was, okay? Hysterical. It goes on. The Georgia Supreme Court referenced an opinion echoing this case in noting when recusal motion clearly has merit. But what if the motion to recuse has merit? What if the judge who announced an oral ruling is, or reasonably appears to be, partial or prejudicial, and therefore has no business continue to preside over the case? See Georgia. What if, for example, so on and so forth. I guess this is a quote. I've never seen a quote written by judges that says what if, but thank you, Georgia judges, for using regular plain language. The alleged contempt is not ongoing and does not require immediate resolution. This court has ample time to transfer this case to another judge who was not involved in the ex parte proceeding, who is not a potential witness to disputed evidentiary fact, and who does not view the harm to be at least, in part, a direct harm to that judge personally and or the sanctity of the judge's own chambers, and who is not called to determine whether the court's own security personnel or reporter committed the alleged contempt. You see what they're doing? you can't determine, they're saying, Judge, you can't determine this contempt because you're a witness. You can't make an impartial decision about your court reporter. You can't make impartial decisions about your security guards. I mean, we were taught in law school during our ethics class that a judge who owns stock in a corporation, if some kind of lawsuit with that corporation comes into their courtroom, they can't hear that case. And I asked, what about if they just have a money market fund and they don't even do it, they just put money in the money market, and the money market owns part of that stock? Even then, the judge is supposed to recuse themselves. Even then, even if you don't know you own stock in the company, you have to recuse yourself. So the fact that this judge is saying, you came into my office and violated my privacy by talking about what happened in my office, it's pretty important for you to not be the judge. He shouldn't want to be the judge of it. He should want it to go to another judge, and he should want to know the actual truth. Okay. Here we go. C. This court must provide a notice that fairly and fully informs the accused of the specific acts of contempt. Remember, in the beginning of this motion, we established this has to be criminal contempt because it only meets certain parameters. So if it's criminal contempt, now you got to do all this. When a contempt proceeding is criminal, the full panoply of constitutional protections must be afforded to the accused. This includes a notice fairly and fully informing the accused of the specific acts of contempt. Like all crimes, contempt has an act requirement and a mental component. The notice alleges that an actus reus, disclosing the ex parte meeting, but fails to put Bumpus on notice of the mens rea, that or how the disclosure would know that such an act amounted to contempt. How would she know she wasn't allowed to disclose it until you started screaming about it? Unless you said on the record in there, which you won't give us a copy of the record, so we don't know if you said on the record this is private. You're going to have to prove that, Judge. The notice does not allege facts from which a contemptuous mens rea could be inferred. There has to be a desire to be in contempt. I'm going to ignore this judge's ruling. It's not pled. It's not in the notice. Okay, disclosure. Now, Bumpus asked the court to quash the show cause or recuse itself or provide a better notice. And if you deny all of that, we want a certificate of immediate review. Okay, now here's something that struck me. We got Julius Collins. Pretty sure that's the guy that was up there this morning making the argument on this. Kristen Nove, John Garland, Matthew Winchester, Nicole Mormon, Mormon, and Gabe Banks. Bumpus has 7 lawyers. And this motion reads like 7 lawyers wrote it. I mean, it is good. It is a good motion. All right, they got the certificate to show. They got the order of show cause. Then, interestingly, and I don't know what this is about, the attorneys then provide an affidavit in support of the motion, which I think is weird. Typically, when I do affidavits in support of my motion, my clients are signing the affidavits. So it's interesting to me that in Georgia, the attorneys are signing the affidavits. Okay. So the judge read this, and he read Steele's, and we already knew he was going to deny him. And this morning, he denied the requests, 100% of the requests in Bumpus's motion. 100% denied. So, that's the Bumpus motion. Goodness, 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 goodness. All right, let me go back here into my comments and see what y'all are talking about, see if you've had any questions. Tamika, I'm so happy you're part of my clan. Thank you. Levy Vegas, welcome from New Orleans. It is afternoon here in Texas. Good afternoon to you. Jay, the Bumpus may be the mole. It doesn't matter. The problem is that the judge never notified anyone and the judge never said that it was private. So how could you be in contempt of a judge's order if a judge never made the order? Kind of difficult. Jody says that it comes out that Bumpus was not the mole. I don't know who is the mole. It doesn't matter because there is no mole because it was never private. Nobody ever said it had to remain private. That is not a thing. Hey, Enya. Hey, Ron Barnes. Welcome. Yes, Glenville is refusing to step down on not just these contempt hearings, the show cause, but he's also refusing to step down over on the main part of the trial. Okay. Seashell, hello, welcome. Also, everyone, I have great news. We are for sure still going to be doing, at a minimum, a meet and greet in August. So if we still have trial, August 13th, we'll be at the trial in the afternoon, and then we'll do meet and greet. But if there's no trial, we'll just still do the meet and greet over in Atlanta. Okay, I know a lot of you made plans. We're going for it. We're doing it. We're doing it. Good morning, Grateful. K-Pick. What makes no sense is Lil Woody doesn't even have pending charges in this case, but it's what came out of Miss Hilton's mouth. Yeah, I don't think he's even part of this case. I don't think he was even indicted, was he? I don't think he's on the indictment. Ron says there were a lot of threats made by the state without defense being present. That's how I understand it from YSL IP, Weinstein's affidavit. Weinstein got into detail, okay? And he definitely, yeah. So, yeah, Jody, the judge was not really trying to hear anyone this morning. Hey, Gary, Indiana, welcome. Hi, Epic, thank you. Jody says there were 14 people in the room when the ex parte meeting was held. There's not a lawyer on the planet Earth. There's not even a law student who has taken an ethics class that would say, oh, well, then it's privilege. There's no way to breach privilege if you have 15 people in the room. Get out of here. Get out of here. Hey, Christian. Good to see you again. Jay, if I were Bumpus, I would have said something too. The fact is I'm not a person who's going to allow the government to steamroll constitutional rights. So if I know that this ex parte meeting took place and I know that's reversible error and I know it's a constitutional violation, I'm speaking up. I'm speaking up. Another day, welcome. Thank you so much. I really appreciate you for joining. Everyone that is in the chat, please make sure you hit like. Okay, you guys, make sure you hit like, make sure you hit subscribe. Kayla, welcome back. I have my Cashapp in the my Cashapp, my email, every way to reach me is in the description of this video. So I hope that y'all, if you want to reach out, you utilize that. Hi, Frederick. Thank you. I really appreciate you being here. Make sure you hit like, make sure you hit subscribe. I don't think there's going to be a Diddy trial. I'm pretty confident that Diddy is in a different country right now. I'm pretty sure that he is in a country that doesn't have extradition, and I would be very surprised if he ever came back to the United States. So, D, welcome. Shouldn't Glenville say, hold up, we need to notify defense counsel? Glenville shouldn't even invite them into his room. When Love says, hey, I want to have this ex parte meeting with you, he needs to say, no. What about? Make a motion in front of the defense attorneys. There's this thing called an in-camera review. Sometimes you need a judge to review things to see, maybe he needs to look at it to determine if it can be admitted in front of a jury or whatever. And then what the judge can do is he can take the piece of evidence back to his chambers and do an in-camera review where he's reviewing it and making determinations. I've never heard of an in-camera review happening without both sides knowing about it. Usually someone requested it. So an ex parte meeting without anybody knowing it it's wild. It's nothing I've ever heard of. Like, this does not happen. This is past the boundaries of, oh, this is happening in courtrooms every day. Okay, we've gotten well into the, oh my God, I can't believe this shit is happening. I've never seen it happen before. All right. TB, thank you. Queen Leo, Glenville was being misled by not naming the state agents. Oh, he's being misleading. He knows he would definitely be recording unlawful acts. He was trying to use intimidation. I agree. Hey, Jean, welcome. Yeah, Ron, that was a great motion. And we're going to get into YSL Steel's motion, which is also a good motion, but I feel like that one I just read is like primo, dude. I mean, top 10 of the motions I've ever read. I really enjoyed reading it. And usually legal writing's really boring, so the fact that I enjoyed it is wild. Yep, Carmela, no court order, no direction that this is private. Just the judge's reaction when he's called out on his bullshit. Revix, welcome. I'm glad you're liking it. Make sure you hit subscribe. Kimbella, yeah, the misconduct is on high coming out of Fulton County. It is crazy. This is crazy. Can the DOJ investigate Fulton County? God, I hope so. I hope they do. I mean, certainly they can. Pretty much we can do anything we want, most people, most things. So I don't know. I would love to see the federal government look into this shit. I was telling my dude last night, I said, like, you know, you read case law in law school where this kind of story, this kind of thing is happening in the case law you're reading about. But when you're reading the case law, this kind of thing is happening in the Jim Crow South 70 years ago, not 2024, not Biden's America, not Trump's America, not modern America. It's like, whoa. Now, in modern America, there are judges ruling on feeling and not the law. There are judges making mistakes. There are prosecutors coming after people wrongfully. Absolutely. But all of that in one pot and ex parte meetings? Nah. Nah. Just crazy. Ghost King, I hope this wouldn't happen in Philadelphia. I hope it wouldn't happen really anywhere in the United States. But obviously it does. Alicia, welcome and thank you. Everyone, make sure you hit the like and subscribe. So BB says it's legal to threaten jail time on civil contempt until the end of the trial if the witness doesn't purge. Yes, that's correct. CJ, Glenville not going to take blame. He's going to allow the appeals to make the call, and Glenville will defer blame on the appeals court. You're absolutely right. Kind of like when he told Bumpus, oh, I'm sorry you put yourself in this position. He's gonna victim blame. Yeah. Mary, welcome. Yes, today Glenville did say he would give chunks and pieces of that transcript. So he will be handing out little bits of it. I want to thank you, my new member, Shelly Small. Thank you for joining for Paralegal. I appreciate it. I thank all my members. It's very exciting to have members, y'all. We do try to create content for our members specifically, and we will definitely be building that over time. Ghost King, the judge became a unity with the district attorney. Yeah, at this point, it's really hard to separate judge from DA. It's really bizarre. Again, read case law about it. Read case law and just thought, oh, I'll never see that. And yet, here it is in front of me. Susan, welcome. She says, this is just a movie. They're acting to get a new courthouse. Everyone will go free. Are we being played? I mean, we're definitely being played, Susan, but I don't know why. Ron, I do agree this judge shows a lot of bias. Shane, I also agree it's a bullshit case. If you go and watch my RICO video, you can see I'm not a huge fan of RICO. I kind of think all of RICO is bullshit. Nomenclature, the entire Atlanta Defense Association is starting to back YT. Yeah, Glenville did this to himself. So now you got the entire Atlanta Defense Bar, the Fulton County Defense Bar. Judges don't want enemies of Defense Bar, trust me. Carmela, can the transcript be altered? Of course. All is possible. Can is not the greatest word because anything can happen. Will it be altered is more of the question, and that I don't know. But absolutely, they can play around with the transcript as much as they want. So, I would hope they don't. I would hope they don't. But people are like, oh, well, can he assault that woman? Like, of course he can. Everyone can. God gave us free will, right? Our laws are retribution. We go after. We don't have preventative laws. So, can, yes. Shelley says Steele's been Thug's lawyer for over a decade, and we can see why. Hi, Douglas. Welcome. King says he don't have any charges, but you don't corroborate, and the judge threatened him with new charges. Yeah, he will be facing new charges if he doesn't do exactly what they say. Alicia, I can't wait you to meet you in August either. And no, Steele is not having to do the sentence time. We did talk about that last week, so make sure you go back. Hey, CG, I'm glad to see you today. Oh, cell block 9 to 5, I feel you. But thanks for swinging in. Let's see, Mike, what issue does the prosecution face for initiating this meeting? Nothing. Nothing. Hey, Lonnie. He says that he's the reason the trial's going on. He told on himself, say he went and washed and blew it. I mean, he told on himself when he said, who parroted this to you? I mean, the word parroted means that it was like copy pasted. Hey, Shelly, thank you for joining the membership. Thomas says, can the transcript be redacted? It is going to be redacted. Glenville said he was going to give a redacted version of the transcript. He's literally going to go pick and choose what they get to see happen. Crazy. And Anthony says this is a prime example of being black in America. Unfortunately, I will never know. Jimmy, Glenville gets high off of having power. Yeah, thank you, Jimmy. I'm glad you brought that up. Oh, Tamika, thank you for the $20 super chat. My God, I love you too. Thank you. Okay, so Jimmy brings up a really good point here. I have been an attorney practicing in courtrooms. Been in courtrooms for 8 years. I've been licensed for 13. I have never, ever heard of a judge putting a lawyer in jail for contempt. I've never heard of a judge holding lawyers in contempt and making them buy lunch for each other. I did do a case. I chose a jury on a case where the judge said, look, I like to ask my counsels to pitch in to buy the jury lunch. That way they don't have to leave. That way we don't have to they can just eat in the back and, you each just contribute. I'll get you lunch too. Everyone pitch in. And we said, of course, we'll join in on that. That's a great idea. A happy jury is a good jury, right? But that judge was not forcing us. It was an option, and it was not a punishment. So I have never, ever, ever, ever seen a judge use contempt and punishment the way this one does. Glenville is out of his mind with power. Out of his mind. And what's scary is this has probably been going on for a really long time, and we're just finding out about it. Bad Sinokia. Sorry, I pronounced that wrong. Now the judge has denied this motion, what can be done? It doesn't seem like the judge should be allowed to be blatantly biased and then make defendant wait until appeal to get justice. I believe that because the judge denied this motion, they should be able to file an appeal right now. And because the hearing is set for the 25th, it should be heard, the appeal should be heard before that, or the hearing get pushed back. D says, why would that amount of law enforcement be present in an ex parte meeting unless it was to intimidate Copeland? Thank you. Why do you need 14 government actors? Unbelievable. Well, I'm sorry, 13, because 12, because Copeland and his lawyer don't work for the government. Andrea says it became privileged when Steel addressed it in court. Correct. As soon as they got called out on their shit. Let's see. Wesley says it's because he's black. Be real. The judge is black. Miss Love is black. Copeland's black. Bumpus is black. I don't understand your comment. The Kimbella says the judge and the prosecution, if they're not giving the information that is needed, they're quick to throw him in jail. Yeah, and half the time when the prosecution doesn't know what they're doing in the courtroom, the judge freaking tells them how to do their job. It's crazy. Ms. Perfect says the judge-acuter. I'm totally stealing that. Judge-acuter. I love it. also thinks that before he provides this transcript, he can take out what he considers to be privilege. Exactly. And there's no privilege. There cannot be privilege. It's 15 people. That's a public meeting. Bad says, call the Georgia Commission on Judiciary. I know that Bad Bunny did that in here, and I would love to know, or Red Bunny, sorry, what your results were. Mustafa says, can the judge rewrite transcripts of the meeting? Yeah, y'all, people can do anything. Whether or not it's legal or right is a totally different question. No, the judge is not going to release the whole thing unless the Supreme Court makes him, I guarantee you. Harlem, welcome. What will happen now since he's denied the recusal? I'm confident that the gentleman that was in there arguing the recusal this morning is at his office typing the appeal right now. Okay? John says nothing going to happen to the judge. That's why he does what he does. I agree. I agree with you. And that's sad. It's awful. Mike says, is there any possible explanation that Glenville offered to justify the meeting without the defense involved? Absolutely not. Violation of the law. There's no way to justify it. Star says, how can he chop and screw the transcripts? Because he's allowed to. Blue, thank you. I'm glad you saw me on SETI, and I'm glad you subscribed, and welcome. Let's see. Oh, Gary says one of Bumpus's lawyers is also Gunna's lawyer. That's cool. Brown Sweet, welcome. How many complaints does the judge have against him? I have no idea. I don't even know how to gather that information. Callie, welcome. She says, imagine if cameras were not allowed in the courtroom. That's poignant. If they're doing this in front of cameras, imagine when there are no cameras, right? Vintage CB, thank you so much for joining our membership. Welcome, welcome, welcome. Tamika says, I just took my ethics course, and my teacher, who's a judge, said this is going to be a part of case law and courses of what not to do. Agreed. 100%. Antonio says the judge is a straight clown. Agreed. TCC Pro says, can the judge edit transcripts? Yes. Nola, the judge and DA are on the same team. Of course, their paycheck is signed by the same person, y'all. Nicole Harris says, us Atlanta taxpayers are upset. Both RICO trials, crime, rent, housing is horrible. Well, Nicole, I gotta say, if I was one of y'all, I would literally be out in the street protesting. I would be lit. Fulton County is wasting your money. Big time. Big time. Kimbella says he's not going to get away with it. I think he will, sadly. Ghosting, it says it's better for him to recuse himself. The RICO was implemented as a door opener to make it a regular criminal case. I think it would be better for him to recuse himself, too. This is what I don't understand. If I'm facing charges, if someone's saying, Lauren, there's something in that transcript that's sketchy, I don't believe it's sketchy, I'm going to say, hell no, it's not. Here's a transcript. Here. If they say, Lauren, I don't think you should be the one making the decision because it seems like you're a witness and you're personally involved. Okay, you know what? You're right. I'm out. Let someone else make the decision because I want truth to prevail. Okay, I want the truth to prevail. I know I'm right. I know I have clean hands. And the judge's insistence on blocking this and preventing this is a statement without using words. Oh, Tamika, that was your first super on a live stream, too. Congratulations. Thank you. You make me feel so special. Nicole says, has Woody's lawyer returned for vacation? I don't know what happened to the white dude. Constance, welcome. Judge always speak for state. Yeah, well, he's part of the state. Alexandria, hope the people of ATL get back from this corrupt folks. Agreed. Lonnie, did I say hi already? I'm glad you're here. The judge snitched on himself. You're absolutely right. Hey Blue Quartz, thank you for joining us. It's okay, you can definitely catch the rewatch. I appreciate everyone that's here live, everyone that comes for the rewatch, literally everyone. I appreciate you so much, okay? Sandra says the judge is worried and not happy he's being seen worldwide. Yeah, well, yeah, he's busted and that's why he's upset. Dee says, why would the judge risk his decorated career for this trial? My guess, D, is that he is risking his decorated career in every trial. There's no way he's acting like this in this trial, and he hasn't acted like this in other trials. This isn't new. He didn't just wake up and be like, oh, okay, let me act like this in this trial. No. No. Julie, how is this even possible? I know, it's awful. It's awful. Not Like Us Gaming says, I've been in court a lot and never saw a judge. Yeah, it's absolutely nuts. Never saw a judge act this way. It's crazy. Bama Boy says Woody is famous now. He is going to remain famous now. Miss Perfect says, can Bumpkis object to the transcript if it doesn't show everything that was actually said? Yes, absolutely. And she should. And she will. I know, because I could tell her lawyers are good just from reading this, okay? Yeah, CJ, the judge had one defense lawyer write a 20-page essay. I mean, this judge is just so contempt happy. I have never, ever, 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 ever seen in my life such a contempt happy judge. It's crazy. He is just drunk on power. Absolutely. Let's see. Willie, welcome. Oh, thank you. Let's see. He's raised in Zone 3. You're glad the world's seeing how corrupt the DEA is. Yeah, it's sad, Willie. James, welcome. Are they really running out of money? I don't see that happening. This trial's supposed to be going on for at least another year. D says, can Glenville face discipline from the military on his actions in this case? I don't know. I don't think so, because I don't think he's definitely not working in his military capacity. So I couldn't see that their jurisdiction could somehow cross over like that. I don't think so. But he can definitely get in trouble with the Judicial Conduct Board. Okay, Julie says she filed a complaint a whole month ago and has nothing back. I'm not surprised. And I'm guessing that the complaints that come from the public or people who are watching are going to just get tossed. That's my guess. The judge still believes in military rule, yeah, but in a weird way. Lonnie, what about how he's chewing on a snack while in the middle of stating he was denying Steele's motion? Hey, it's his courtroom. He can do whatever he wants in it, Lonnie. Charlene says that that's the sad part, black people hurting their own, and that would, in fact, very much be very sad. Tracy says appeals don't mean anything in court, and that is true. Tamika says, race or not, I'm glad this is being shown in the corrupt state. The biggest point is that they bring awareness to the younger and unaware audience. I agree. And I feel like the more people that see stuff like this, the more people that are able to participate, the better jurors we'll have. Because when you get called for jury duty, you're going to do a better job. You're going to understand what beyond a reasonable doubt means. You're going to understand what that burden is for the prosecution. You're going to understand a lot more and be able to be a better juror. Unpopular opinion says, what happened now that he's on the record telling everyone he's redacting the transcript? Nothing. He's just going to redact it. Plans and Pens, welcome. Glad to see you back. Yes, I know prejudice against... Look, I'm prejudiced against tons and tons and tons of people who have white skin, okay? Race and prejudice are not always correlated. But this judge's bias is clearly in favor of the prosecution. Okay? He is clearly biased against the defense. And I think Brian Steel, and I'm about to get into his motion because I'm almost done with the comments. I think Brian Steel is having a hard time figuring out, is Glenville biased against me, Brian Steel, or is he biased against Jeffrey Williams? And I'm guessing the jury can't tell either. Okay, my understanding is Steele has overturned through his appeals more than one of Glenville's rulings. So it's pretty bad. Hi, Tyrone. Thank you for joining. CJ says appeals court is like your last lifeline. It's been for years. Yeah, this whole, we'll see what the appeals court say. That's just bullshit. That's just like throwing it off. It's like this. If you're in a two-parent household and you're the child in a two-parent household and you go ask your dad and he says, go ask your mom, that's what Glenville is doing. When he says go to the appeals court, he's telling you go ask your mom. He's like, I don't give a shit. D, I don't know what hearing on Tuesday you're talking about. Thomas, welcome. Nicole, I'm glad you saw me on Steady, and I hope you subscribed. I'm glad that you're here. Let's see. Math Fairy Fun says there's no difference between the judge and the defendants that stand before him. Oh, I would argue there's a huge difference. The judge has sworn and taken a vow and an oath to uphold the law. And the defendants have not. So there's a big difference. The judge has an onus to follow the law. The defendants do not. They're just regular people. D, what is Tuesday? Is Tuesday the 25th? Are you talking about the show cause? Because the show cause is going to end up being delayed on the appeal that's going to be filed today. Tukey says all Steel needs to do on cross is ask Woody what was said to him in front of the jury. Oh, Steel has made it clear today that he will be crossing Woody about what was said in that ex parte hearing. Oh, yeah. Harlem says, do you think the Supreme Court of Georgia will do something to recuse him? No. I think the Supreme Court of Georgia is going to see the transcript and the ex parte hearing, and they're going to call a mistrial. So I don't think they're going to recuse the judge. They're going to call a mistrial. So that's what I think. Julie says, I urge Fulton County residents to go protest at the courthouse, and I think so. John says, can they sue the judge? No. Sovereign immunity, guys. Steel is going to do it. Can Steel file an appeal against the judge? Yes, and he already has. Does Glenville select the court officers? Like the cops, the bailiffs and stuff? No, usually they're just assigned. Joseph says, could Steel file an emergency appeal for the Georgia Supreme Court to review Glenville recusal? He doesn't need to. The Supreme Court's already going to be reviewing the contempt, so there's really no need. All of this recusal stuff is just to preserve the record. Rachel, the only person who can stop this judge is the voter. So those of you who are in Atlanta and you're voting, don't be voting for Glenville. Sherman's View, from time to time, I hear Lil Hood slang in you. Where are you from? I am born in Austin, Texas, raised in Scottsdale, Arizona, went to law school in San Antonio, Texas, and I have been living in Oak Cliff in Dallas for over a decade. So that's where you get that little bit of hood in me. Good news, welcome, thank you. How does immunity work for the states if the feds decide to pick up? It doesn't. A state immunity is only as good as the state. The feds can still come get you. Gary, Indiana says, wild that Woody really started and stopped this whole damn case. Isn't Woody like a short king too? Like, he looks so tiny. He looks like a doll. Someone said last week, I said he looked like a doll. What kind of doll does he look? They said, My Buddy. You remember the My Buddy and Kid Sister? Man, I wanted one of them Kid Sister dolls so bad. My parents said they were too poor. Turns out they weren't. They were just lying. They didn't want to spend their money on it. D.A. Love is in the middle of Woody brother trial. Wait, if that was brought up as a leverage? What do you mean, CJ? Give me some more elaboration. Yeah, I wish we could stop this madness, but we really don't have necessarily a way to do that. We're actually pretty lucky that the judge held Steel in contempt, because now the Supreme Court's going to see some of this stuff, right? So I think that's actually a huge fortune for the defense. Crystal, welcome. She said the same thing watching this trial. This is not new behavior. No, this man did not start this yesterday. Glenville didn't just like wake up and decide that Thug is going to be his first victim. No, he's been this way. And you could see that because the lawyers, you could tell, don't like dealing with him. So you could tell that they're displeased that he's their judge. We all have judges like that. Like, there's certain judges I know it's just going to be not a fair case for my client, you know. So what sucks is that Glenville is their chief judge, so he gets like the big high profile cases. Okay. Yeah, Yvette, the fact that the judge is like screaming and defending this meeting is absolutely wild to me. All right. I agree. If the defense can get a copy of that audio, that's exactly what they need. Yeah, the blue courts, this trial is completely reversible based off Love's opening.
January 28th of 15 and February 21st.
They came back on, guys.
So, Your Honor, I don't believe we've even started on the 21st yet. However, for January 28th, I have 6 more redactions to confirm, and I believe Mr. Shar says he has 9 more.
good news and some
Okay news. The okay news is we're not quite done. We're on 11. We finished 11 out of the 17, reviewing 11 out of the 17 states' proposed redactions. I can say in the state 1 we're okay with, 2 we're okay with, 3 we're okay with, 4 we disagree and we're okay with, except we believe 722.35 to 724.01 should stay in. 5 we agree with, 6 we agree with, 7 we agree with, 8 we agree with, 9 we disagree with, 10 we generally agree with, except we believe 751.19 to 751.22 should stay in. And we can talk about that. 11 we disagree with. So that's where we're at. So we do have a fair amount of agreement.
okay.
Thank you, Tamika.
All right. I have an unrelated matter to take up in a few minutes, and I'll check on you all probably around 3 o'clock. Okay.
Yes, Your
All
Honor.
right. So continue your work. I stand in. All right.
Okay. Judge is going to his 2 o'clock appointment. He said he had 2:30. He has. All right. Okay. So we're gonna get right back into where we were at. Okay. Yes, Constance. Oh, Cliff, that's my hood. That's our song, y'all. I'm always surprised by people who've heard that song like far and wide. You know, like yes, that's the Oak Cliff I'm from. Okay, so they're working on their redactions. They're getting their evidence moving along. Here we go. Let's get back into it. All right, I'm going to go back and we're going to start on this Steel motion, all right? All right, here we go. So, on the 17th, yesterday, at 4:59 p.m., this motion was filed. Now, I'm relatively confident that Steel physically handed the motion to the judge before it was e-filed, okay? Because I heard the judge and saying he would deal with it tomorrow. Okay. And tomorrow being today. So, they dealt with this already this morning, but we're going to get into the contents of what they were dealing with this morning, okay? Thank you, Jiggy, for the compliment. I really appreciate it. Lamar, I don't think this trial is going to go all the way. I really don't. Oh, and TCC Pro, I will tell you all what beyond a reasonable doubt means. So let me get through this, and then we'll talk about BRD. All right, here we go. Now comes Jeffrey Williams, by and through undersigned counsel, and hereby files this motion to disqualify, blah, 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 blah. They represent Jeffrey, and the trial is supposed to last through the end of the 2024 calendar year. Monday the 10th, within 5 days of filing this motion. Now, that kind of confuses me. I guess they're saying 5 business days or something, because this was filed on the 17th. The 10th to the 17th is 7 days, not 5. So I'm guessing the judge ruled that it was timely filed. So I'm guessing that they're talking business days when they say 5. I think that's a fair assumption there. Okay. Let's see. The order of use immunity had been issued. No notice of this ex parte meeting was provided to any attorney for any of the criminally accused in this case. In fact, the accused and their counsel were in the dark that this Star Chamber meeting occurred between Mr. Copeland had previously been called to testify on Friday, June 7th, asserted his Fifth Amendment privilege in open court in front of the jury, and was held in contempt and summarily incarcerated until such time as he agreed to testify pursuant to the grant of use of immunity. I kind of got to wonder about that too, guys, because one thing that I don't like the idea of is that you can be called to testify and you say, I want to take my fifth, and then they say, well, we're forcing immunity on you, so you have to testify. I feel like the immunity should be a choice. I think sometimes when people plead the fifth, they don't want to testify, not just because they don't want to incriminate themselves, because they don't want other people to come kill them or hurt them or whatever it may be, right? So I don't like this idea that the judge can just be like, well, you're immune, so now you must speak. Like, that seems and feels very un-American to me. All right. Glenville and the prosecutors essentially admitted by silence and by statements in open court that ex parte meeting occurred the morning of June 10th, only after underside counsel revealed, based upon information and belief, that this impermissible meeting occurred. At the earliest opportunity on the afternoon of June 10th, the court was informed based on upon information and belief. When we say based upon information and belief, that means like hearsay, based on, someone told me, or I think this is it. Sometimes in a pleading, if I have a client who says, well, this happened, but they don't actually have like a physical piece of evidence to prove to me this happened. Sorry, Belinda took away my sheet of paper that I was waving. They don't have like a physical piece of evidence that shows, like, I could be like, yes, I know that happened. Then I'll write upon information and belief. Okay, because it's like, it's kind of a guess, but it's like a little more than a guess, but I don't want you quoting me necessarily. All right. Upon information believed, the ex parte meeting with the sworn witness Copeland and the prosecutors occurred earlier that day. The witness had made factual admissions, and the statements were made to the witness by the court and the prosecutors acting in concert about the amount of time Copeland would be held in custody for contempt. The court denied underside counsel's request for the transcript of the ex parte meeting and denied the timely motion for mistrial based upon this improper and illegal ex parte meeting, which violated Mr. Williams' constitutional and statutory rights, including the right to due process, a fair trial, fair tribunal, ethical prosecutions, and right to be present at every critical stage of the Constitution. Okay, I'm going to pause. Can y'all see and hear the difference between the Bumpus motion that I just read you and this motion in the writing style and in the we'll say passion? Okay, so the Bumpus motions that we just read was very this, that, oh, I'll say it like they say in Atlanta, this, that, and the third, okay? But in this one, it is already very, I don't want to say it's not using puffery necessarily, but it's using much more emotional type words, in my opinion, as I read it, than the last one. Okay, so this one you can tell was passionately written. One thing I noticed is that they have a link to the Law and Crime YouTube. In case the judge didn't see what was going on Monday, they can go watch it here. But I think that's more for the favor of the appeals court and the Supreme Court. And I really wish they put my YouTube link in there. Come on, guys. Okay, Uniform Superior Court Rule 4.1 and Georgia Code of Judicial Conduct 2.9 delineates rules governing ex parte communications. They're generally prohibited. They're only authorized in extraordinary matters such as temporary restraining orders or temporary injunctions. Now, last week I gave an example. If Woody was being threatened by one of the defendants, then maybe there would be an extraordinary reason to have this ex parte hearing, okay? And to talk, but that meeting, meeting would have to strictly be about the threats and the fear. So it's crazy. All right, so they go ahead and cite the entire code. The court violated USCR 4.1 and Georgia Code of Judicial Conduct 2.9. The court has joined the prosecutor's team and is biased against Mr. Williams and favorable to the prosecutors as objectively demonstrated on June 10th, as well as throughout the pendency of this case. Here's where you know it's about to get good. It's getting juicy. It's getting juicy. The trial court rejected undersigned counsel's substantive request for information about the unlawful ex parte meeting. Now remember, in Bumpus, they just called it the ex parte meeting. But in this one, it's the unlawful ex parte meeting. Now, my legal writing tends to be a lot more like Mr. Steele's, okay? I know this is going to come as a surprise to 100% of you. But I'm kind of dramatic, okay? I know, you're floored. What? Lord Cadillac? OG Cadillac kind of dramatic? What? I know. Take a deep breath, okay? So when you read my motions, you're going to see they have things like unlawful ex parte meeting. They're going to have a little bit more flair, so to speak, okay? A little more dramatics to them. Here we go. I mean, this one gets so dramatic. Unlawful ex parte meeting, and the court denied undersigned's counsel for motion for mistrial. Instead, the court stunningly demanded to know how undersigned counsel came into possession of information about the ex parte meeting. The prosecutors stunningly sat mute and permitted this injustice to occur and for the court to attempt to intimidate undersigned counsel. Later, Love, a lawyer currently employed with the Fulton County District Attorney's Office. Now, they got to remind her who she is because, remember, she's an ex-judge and she thinks she runs that courtroom. Okay? So you got to remind the bitch who she is. You're on the DA's payroll. Argued that the ex parte hearing with witness Copeland was ethical, just, and proper. The other prosecutors still remained mute. I'm going to guess that's because Miss Love's a bully. I'll show you this morning where she's making these faces at Hilton, yo. Like, she is making some faces at Hilton. And I am telling you, if I had to work with her, I couldn't. I could not work with Miss Love. You could not pair me with a bitch like that. Okay? You cannot have two women such as myself and her next to each other working together. I would smack the shit out of her. No, I probably wouldn't. I've never actually hit a person. That's not really my thing. But I would want to smack the shit out of her. How about that one? Okay. I just love the dramatic way that Steele writes. Undersigned counsel declined to join the antics in ignoring rules and ethical provisions and declined to provide information requested by the court, relying on State Bar Rule of Professional Conduct 1.6, which states in pertinent part that a lawyer shall maintain in confidence all information gained in the professional relationship with a client, including information which the client has requested to be held inviolate or the disclosure of which would be embarrassing or would likely be detrimental to the client, unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation or are required by these rules or other law or by order of the court. Well, oops. There's that, by order of the court. Oops. But we get into comment 5. So, y'all, being a lawyer is ridiculous. So we have all these rules, right? We've got like 800 million rules. We got the rules of evidence, the rules of procedure, the rules of this, the rules of that, the rules of professional conduct. And then sometimes in the rules, we have these comments, which are like descriptions about the rule that like tell you more about the rule and are part of the rule, even though they're not written in the rule. Okay. The principle of confidentiality is given effect in 2 related bodies of law: the attorney-client privilege, which includes work product, and the law of evidence and the rule of confidentially established professional ethics. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also all information gained in the professional relationship, whatever its source. Whatever its source. A lawyer may not disclose such information except as authorized by law or required by the Georgia Rules of Professional Conduct. So, all along, Steele has been saying, look, Judge, you are putting me between a rock and a hard place. The rock being your order and the hard place being these rules that I have to abide by, or else I will get a grievance. And they're spelled out right here. Spelled out right here. The court ignored the ethical rules relied upon and continued to demand the undersigned counsel to review the source of the information, claiming that the way that undersigned counsel obtained that information was somehow unlawful, and baselessly accusing undersigned counsel on the record of potentially acquiring the information through eavesdropping. Now, one thing I noticed, and I don't understand, is why is this first quotation mark backwards? It should look more like this first quotation mark. So I don't know what happened there, but I did notice that little bit of typo. In response to the specious accusations and the impermissible demands of the court, you guys, the dramatics is on high here. Undersigned counsel relied on the ethical mandates of 1.6 and the Fifth Amendment right to remain silent and declined to provide the source of information which had been proffered. The court is so biased against undersigned counsel and or Mr. Williams, the court ignored all laws and pursued contempt penalties to attempt to intimidate undersigned counsel to violate the law and ethics in order to continue to help the prosecution convict Mr. Williams and others. Whoa. Whoa. Now, I write some dramatic shit in my pleadings, but that's a little stronger than I'll usually be willing to go. I'm not gonna lie, guys. I feel like if my son were to represent my daughter in a trial in my own home, this is the kind of, I feel like my son would write this motion if I was the judge. You know, it's not a way I would talk to. I would talk to a lawyer, or to a judge. But man, it's powerful. All right, the court has issued a written order of contempt. The Supreme Court has granted a writ and granted a supersedes bond, meaning he doesn't have to go to jail. The court violated the law by failing its duty to recuse from presiding over this contempt proceeding. In such proceedings, where announcement of punishment is delayed, and where the contumacious conduct was directed towards the judge, or the judge reacted to the contumacious conduct in such a manner as to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. We've already heard half that language. We saw a lot of that language in the Bumpus. We heard this contumacious conduct. It says here, though, must be conducted by another judge. That's not even a choice. That's a mandate. Okay. Here, the court involved itself in these proceedings by joining the prosecution team and conducting the ex parte meeting that violated Mr. Williams' rights. This created a conflict of interest for the court because its own unethical conduct is questioned and at the heart of this issue. The court then compounded its abuse of power by presiding over the very contempt hearing where its own rule violations prompted the controversy. The court should have recused and allowed the contempt proceedings to be handled by a separate court. Further, the prosecutor sat mute and permitted the court to attempt to interrogate and intimidate another member of the bar who reported a violation of law, and also prompted the court's wrongful conduct by asserting that the ex parte meeting was proper. So Steel is saying this prosecution is as guilty as the judge because they're allowing this. They're not saying, hey, judge, we're not allowed to do that. Judge, Your Honor, we're not objecting to that, and my understanding of the law is blah, blah, blah. But they've remained mute, so to speak. The court denied Williams and counsel their due process right, and counsel has a right to adequate notice to be heard, to call witnesses, and to be represented by counsel for the entirety of the contempt proceedings. And Williams had the right to learn all in the facts and circumstances of this critical stage in the proceeding that occurred in his absence ex parte. The court abused its authority by holding undersigned counsel in contempt for refusing to divulge privileged information and for protecting Mr. Williams' constitutional rights, due process to fair tribunal, right to a fair trial, right to present an effective assistance of counsel. This court's refusal to acknowledge these rights and protections has created an unfair tribunal based upon bias against Mr. Williams and or his counsel and favoritism to the prosecutors. No doubt about that. No doubt about that. Motion to disqualify recuse Judge Glenville is timely as filed under the rule. It mandates no later than 5 days. Supreme Court of Justice has taught that a motion is good, so their timeliness, blah, blah, blah. The record reveals numerous okay, here we go. The record reveals numerous incidents during trial when the judge's behavior appears to have been biased against Mr. Williams' counsel and partial in favor of the state. We have seen this. We have sat here and witnessed this. We have seen the judge coach the state. We have seen the judge become the prosecution. Okay? So this is not a surprise to us. So then he cites the case law, and these parentheses is a little description of the case law. The record reveals other instances too when the trial court wrongly berated counsel in front of the jury. We remember that. After a number of such incidents, Mr. Williams' counsel, outside the presence of the jury, moved for the recusal and sought a mistrial on grounds that the judge had shown a lack of objectivity and had displayed bias and had assisted the prosecutor in making their case. Judges have an ethical duty to disqualify themselves from any matter in which they have personal bias or prejudice concerning a party or an attorney appearing before them. Now remember, I said Steel cannot tell the difference. Is it Steel he hates? Is it Mr. Williams he hates? I'm thinking it's Mr. Steel, if I'm honest. I'm starting to think it's Mr. Steel. The Code of Judicial Conduct provides judges should disqualify them from themselves from proceeding in which their impartiality might be reasonably questioned, including but not limited to instances where the judge has a personal bias concerning a party or a party lawyer. Within the context of the requirement, the word should means shall. Supreme Court is mindful of the extraordinary pressures attending criminal trials on this magnitude. On the one hand, defense is obligated to vigorously defend his clients against all charges by the state. Likewise, the prosecutors must effectively and ethically present the state's case to a jury. And at the same time, the judge is charged with ensuring that the rules of evidence and procedure are followed and the proceedings are orderly, ethical, and fair. Now, I gotta say one thing. There has not been a single Oxford comma in this whole document, and it is pissing me off. Ethical, comma, and fair. Anytime there's a list, you comma and you comma before the and. And I know there's this whole thing about, oh no, you don't need the Oxford comma, but a judge came down with a ruling where basically the ruling is summarized as use the fucking Oxford comma. That is all. It's the law. Use the Oxford comma, guys. So annoying. Or maybe he means orderly, ethical, and fair. Maybe he doesn't mean orderly, ethical, and fair. That's how he wrote it. Orderly, ethical, and fair. Not orderly, ethical, and fair. If y'all take anything away from today, I hope it is to use the damn Oxford comma. When these several interests come together in the courtroom during trial, disagreements between the bench and bar are to be expected. In the instances discussed above in the attached Exhibit A joint affidavit, however, represent more than just mere friction between zealous counsel and a diligent jurist. The judge's conduct, as discussed as above and herein, creates the impression that he harbored an inclination to be biased against Mr. Williams and his counsel and partial towards the prosecution. Higher courts need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where a judge's behavior could indicate that he has a personal bias or prejudice concerning a party or party's lawyer. As explained, the trial judge in this case participated in ex parte communications with the prosecutor in which he assisted the state to influence a witness to testify against Mr. Williams. These actions certainly raised reasonable questions concerning the judge's partiality and bias. Because the trial judge's impartiality is reasonably questionable, it is an error to deny Mr. Williams' motion for recusal. Our highest court has set 3 circumstances in which a recusal of court is necessary on the grounds of mere appearance of bias, even in the absence of evidence of bias. Okay? So this is 3 times where you don't even need hard evidence. It's just an appearance and you got to recuse yourself. Mr. Williams does not waive actual bias has been objectively sown throughout the trial as well as on June 10th, but for simplicity, the appearance of bias is also met. 2 of these circumstances arise in the case of Barr. First, mere appearance of bias requires the recusal of a judge when the judge becomes embroiled in the controversy with one of the litigants. Is he not now embroiled in a controversy with Mr. Steel, with YSL Steel, about this contempt? About who said what about the ex parte? I think he is. Georgia courts have followed this demand for recusal when judges become embroiled in the controversy. These are all examples out of case law. Second, due process requires recusal of the judge when the judge takes a role in the accusatory process. Highest court explained that the Constitution prohibits a scenario where the judge orders witnesses to appear before him in order for the judge to gather facts to determine whether contempt proceedings should occur, and then the same judge preside over the contempt. This is because such a judge/grand jury arrangement caused the judge to become part of the accusatory process, and thus the judge must be recused from further dealings. Here, Glenville ordered Copeland's lawyer and others to appear to give information in a contempt proceeding. Same is against the law. I love YSL Steele's writing style. I love this. I like Bumpus's better. I like what her lawyers put together better in terms of like legal writing, but in terms of like entertainment and dramatics, this is it. This is great. Importantly, a trial judge has the duty to recuse himself sua sponte. Sua sponte means on your own. The judge can do things sua sponte. That means without a motion, just on their own. From any proceeding in which the judge's impartiality might reasonably be questioned, including certain instances where the judge has a personal bias or prejudice concerning a party. The phrase impartiality might reasonably be questioned means the existence of an objectively reasonable perception of lack of impartiality by the judge held by a fair-minded and impartial person based on objective fact or reasonable inferences. So you can't come to lcadilac and ask if the impartiality would be questioned, because I am not impartial and I am not fair-minded. I am always against the government's position. Very rarely am I supportive of the government's position. To warrant recusal, the alleged bias must be of such nature and intensity to prevent complaining party from obtaining a trial uninfluenced by the judge's prejudgment. To warrant disqualification of the trial judge, affidavit in support of a motion seeking the same must support the charge of a bent of mind that may prevent or impede the impartiality of judge. I don't know what that bent of mind means, but I'm thinking that's some kind of Georgia language. Recusal is objectively required when the judge serves both as the accuser and the adjudicator. That's the case with this contempt. He's accused them of contempt, and now he wants to adjudicate it. He can't do it. In the case of Barr, the court met ex parte with prosecutors. The court has become part of the executive branch prosecuting Mr. Williams. The prosecutors have abandoned and violated their ethical duties by engaging in this meeting and sitting silent while the court held undersigned counsel in contempt and failed to reveal any Brady evidence from the meeting, including the fact that the meeting occurred. The court and the prosecutors should not be working together, but they are, teaming up to gain an unlawful advantage over Mr. Williams. Mr. Williams' trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards and protections of due process of law. The court is biased against the accused and his counsel. No intellectually honest person could believe that coercing witness Copeland to testify in a star chamber setting meets constitutional muster. I'm totally going to borrow that one. No intellectually honest person could believe that coercing witness Copeland to testify in a star chamber setting meets constitutional muster. Muster, not mustard, guys, sorry. Write that one down. No intellectually honest person. My goodness, I love that. Nomenclature, thank you so much for the $10 super sticker. I appreciate y'all too. Or if I were my 19-year-old son, I pre you. That's what he said instead of appreciate. He said pre. And my daughter and I are supposed to know what that means. Okay. The court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, judge, grand jury, bias, partial, potential sentencer, and thus must be removed from the case in toto instanter. I don't know what that means. I don't know what in toto means. I don't know what that means. And I've never heard of instanter. I don't know what either of those things means. If y'all want to look them up and tell me, I would love that. On a motion to disqualify recuse, it's the duty of the judge to pass only on the legal sufficiency of the facts alleged and to ask whether these facts support a charge of bias or prejudice. Neither the truth of the allegations nor the good faith of the pleader may be questioned. So, this says, Judge, when you're reviewing this disqualify, you only get to look at the legal sufficiency of the facts alleged and ask if those facts support a charge of bias. That's all he can do. Doesn't get to think about the truth. He doesn't get to think about good faith. That's it. The test is whether, assuming the truth of the facts alleged in the affidavit, a reasonable person would conclude bias exists on the part of the judge. That's it. That's your only test. That's your only measure. Well, we know Glenville went past that this morning. This court's conduct raises a strong finding that it has become personally embroiled in the case. It is clear, even to a casual observer, that this court's involvement in this controversy requires this court to be disqualified, recused, removed from all further proceedings in the above referenced case, instanter, and another judge who will duly exercise the powers of the judicial branch with partiality, clarity, and fairness must be appointed to this case. In that sentence, you are saying, Judge, you are not partial, you are not clear, and you are not fair. That's what that sentence says. It is critical to the functioning of our courts that the public believe in the absolute integrity and impartiality of its judge, and judicial recusal serves as a linchpin for the underlying proposition that the court will be fair and impartial. The Georgia Rule of Conduct mandates a judge must disqualify himself in any proceeding for which his impartiality is reasonably questioned. I feel like we already said that. This motion, accompanied by the affidavit, mandates that the judge shall immediately cease to act and shall immediately determine the timeliness of this motion, and assuming them all to be true, determine if recusal is warranted. If it's found that this motion is timely filed, which it is, the affidavit is legally sufficient, it is, the recusal would be authorized, some or all of the facts set forth in the affidavit are true, which it does, Judge Glenville must cease from any further contact with this case, and another judge shall be assigned to hear this motion. Glenville cannot in any way oppose this motion. So this morning, we saw Glenville, and he said that he was ruling it was timely, but he wouldn't go forward with the recusal. Now, if you go watch my appeals video, now that the judge has made this ruling that he's not going to recuse himself, Steel should be able to go for an interlocutory appeal on this matter. The joint affidavit sets out the facts. The allegations are not just bare conclusions and opinions, but facts. Glenville must disqualify. I mean, we're seeing the same part. The facts cannot be ignored, so on and so forth. The indictment must be dismissed, a mistrial granted, and upon the court's and prosecution's continued misconduct, a constitutionally required fair trial occurring before a fair tribunal with ethical prosecutors has been violated. This includes, but has not been limited to, witness intimidation. Judge Glenville, lawyers for the state, Love and Hilton, will be called as witnesses at a trial for the jury to understand this ex parte meeting and determine demeanor and credibility. Additionally, Williams demands all ex parte meetings to be disclosed, and in order to properly reveal full extent of violations. Lawyers for the state, Love and Hilton, and Judge Glenville are necessarily witnesses to this hearing. Based upon the above, we respectfully submit. Okay. Exhibit A is the contempt order on Steel. And Exhibit B is the joint affidavit of YSL Steel and YSL Adams. Okay. Here we get what I find interesting is the affidavit is not just the affidavit has the puffery and stuff. Right here it says this court has obstructed Mr. Williams and below affidavits from having an exact image of what was saying. This obstruction alone shows the court is biased and there is no privilege in communication in this court chambers, as the court argued, and there's no client privilege in any stretch of the imagination, as the court asserted. This obstruction is conduct by the court shows bias, and the court is intrinsically intertwined in the facts of this case and has prevented Williams from due process, fair trial, effective assistance of counsel, right to know every material and critical happenings of the case. Further, the court, by its words, uses the record when speaking in open court, as well as the court's silence, as well as lawyer Love's statements in open court. Now remember, she's an ex-judge, so they're calling her lawyer Love to piss her off. It is what she is a lawyer, she's being a lawyer, but you know it's going to make her little ego mad. You know lying Love cannot handle that. We know Lion Love cannot handle just being a lawyer. I'm a judge. I'm the honorable Miss Love. No honor in that one. The court has silenced witnesses by doing the show cause, blah, blah, blah. Copeland's a witness. Deputies were told to turn off their body cams. There is nothing privileged under the law about this ex parte meeting. They met with Copeland for more than 1 hour, approximately 2. Told him he'd be held in custody until he testifies. If he persists in refusing, he'll be held in not only till Mr. Williams' trial resolves, but also all 26 indicted persons are resolved, whichever is longer. That's what he was threatened with, allegedly. This court was a participant and was present during these threats. This is witness intimidation. This court, lawyers Love and Hilton are all witnesses. It's not a good look. This court provided Copeland with a written copy of the statute, which isn't on its own completely terrible, but in considering the circumstances, it's really not great. Lawyer Love made representations to this court in front of Mr. Copeland and his counsel and others that Jonathan Melnick, counsel for Copeland, committed misconduct during his representation of Copeland and was not representing the interests of Copeland. Remember that, guys? Remember she got up and accused Melnick of malpractice, and then when he went to defend himself, she pushed him with her ass, pushed him out of the way so that he couldn't finish defending himself against her accusations. That's when he said, no, I sent her an email telling her I was his lawyer, and I'm going to let the state bar know about this. I hope the state bar does learn about this. Lying lawyer Love, she's not doing it great. These are knowing misrepresentations by lawyer Love to this court, which lawyer Love continues to do, which biases this court in favor of the state and against the accused, their lawyers, and other members of the bar. The court permitting lawyer Love to speak ill of Mr. Copeland's counsel in front of Mr. Copeland adds to coercion and witness intimidation. Drop the mic. You let her talk shit about him in front of his client. That is part of the intimidation. Oh, look, your lawyer's not good. He didn't give a fuck about you. That's a way to intimidate someone. Ridiculous. Okay, so we got the constitutional. Now here's where they quote Bumpus. These facts are adopted. They adopt everything Bumpus said in her motion, which we just read. This court never assured that Brady evidence would be revealed to Williams or his counsel. Instead, the court takes a position that no information about this meeting should be revealed. Now, this was all true yesterday, but again, the court has now said today that it's going to come out with like a redacted version of what happened. On Monday afternoon, we made it known in open court, and you held us in contempt. The court has become a material witness. This improper meeting, and this is not, okay, so this was important, I thought. This is not an ex parte meeting that the court has had with affiants ever. On the very few occasions that affiants have had an ex parte hearing with this court, affiants announced in open court that it needed to speak with the court ex parte, and there was no objection from the prosecution. So they have never had a secret ex parte meeting with the court, is what they're saying. In the rare times they had ex parte, because don't forget when this all went down, Glenville was like, oh, just like if you had a meeting with me. And they're like, well, we never had a meeting with you. This is bullshit. The court has been fed improper ex parte information about facts of this case. The court has met with witnesses, which is just wild. The court is now placed the lawyer for Copeland and other unknown persons in a position where they need to come forth and give testimony. The court has become the executive branch conducting an investigation as grand juror prosecutor. Now, see, these, in my mind, aren't typically the words you see in the affidavit. Typically in the affidavit, it's like, on this day and time, this happened. On this day and this time, this happened. On this day and this time. So this affidavit is full of a lot of language that isn't typically in an affidavit, necessarily. Okay, the court has accused Brian Steel of being unprofessional and unprepared. The prosecutor sat silent when he was falsely accused of improper conduct. This court has violated every neutrality, impartiality that was sworn to undertake. Ooh, every single one. When Copeland took the witness stand, he refused to testify. Williams, let's see, Copeland assessed his Fifth Amendment. When the Honorable David Botts, okay, Honorable David Botts ESQ. Now that's how he must have been a judge. And they would call her the Honorable Miss Love if she was honorable. When he brought attention that he had evidence the court prosecution knew Copeland was going to invoke his Fifth Amendment right, the court refused to have a hearing to determine whether the prosecutors knew. Instead, the court had a problem with Attorney Botts. This is backwards. Oh, Botts is the old dude. YSL Grandpa is Botts. And remember, when YSL Grandpa got up and he said, no, I did hear all that, the judge was like, well, I'm mad at you for not telling me earlier. Because, like, oh, yeah, your timing is absolutely what's at issue here. Okay, in sum, the court must be refused. Excuse me, recused. And I swear it's true and accurate. Whew. Certificate of service. I definitely screenshotted this so I could have everyone's email. Is it beneath me to send emails to Adrian Love? No. Not at all. Okay, let me go back to like this morning real quick with y'all. So this morning, Steel was promised that he would be heard this morning on this issue, and Bumpus was heard this morning on this issue by way of her attorney. So let's just go. Interestingly enough, like the cameras came on kind of like midway.
Bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
Please. And I'm not trying to. I understand the court's ruling, and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency.
It does a lot of ums. A lot of ums. One thing I did notice is this man who is talking, he sounds a lot like YSL Silver Fox. Like the way their words sound, even like the sound of their voice is very similar. And I wonder if maybe they grew up in like the same area or something, because they both kind of take the same tone.
Of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be. I mean, the appellate court will review my ruling for abuse of discretion.
Certainly understand that, Judge. And stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument.
Okay.
I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time,
Sure.
Other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take?
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. Mm-hmm. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and or Brady. And for that, and I will do that. And then so if that pertains or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record.
Okay, all right, but I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that would be an established fact at the hearing. We also...
But I can't take it. It's not something I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your client.
Sure.
That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You've made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right.
I'm about to show you Miss Love and her behavior.
Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
Of course not. Of course he won't grant it. I don't think Miss Hilton is going to get fired, y'all, and I don't think Miss Love is
I
going
have
to get
read
fired
Baptiste versus State. I've read all the cases that I believe are applicable, as best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal 392 Division 1 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I've added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him.
I'm going to
And
ask
you're going to
him.
be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams.
Okay, I see in these comments you got to use headphones because I curse. Y'all, your children should hear curse words because they're going to use them and you want them to use them right. You do not want your kid using curse words incorrectly, sounding like a damn idiot, okay? I use curse words in front of my children. They're allowed to use them in front of me. You just don't use them in front of teachers, principals, or cops, okay? But no, when you grow up, you're going to use curse words, and I'm not trying to have a kid who doesn't know how to curse right. That is so embarrassing when people don't know how to curse proper. So let me teach them. Y'all, if you don't feel comfortable saying curse words in front of your children, put me on speaker so they can hear a highly educated woman using them properly. All right? I have my favorite quote in the world comes from a play called Inherit the Wind, which is about a trial in like Alabama where a teacher was teaching evolution, so he was put on trial. And there's a lawyer who comes from Chicago and he curses all the time. And they're like, why? And he says there's damn few words that people understand. So I'm going to use all of them, particularly the ones that people understand. All right. But I won't be cursing in the courtroom unless I'm like reading a quote. I don't think Miss Hilton is going to be fired. I don't think Miss Love is going to be fired. I honestly think that Miss Love will be assaulted by one of her coworkers before she gets fired, okay? And I'm going to show you here in a second why. I didn't get to show you on Friday because they came into court and we didn't get to finish watching the green suit on Thursday. But the fact that Hilton did not punch Love in the face on that day means that Hilton deserves sainthood. Okay.
So I just asked you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I asked the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not gonna, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're going to have to put those in some other pleading. But at this point, Miss Weaver's going to prepare the record. She does that, And like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers. Less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Tasha, the certificate he's refusing to grant would allow them to immediately go to the Court of Appeal.
Thank you. All right. Okay. All right. Let's turn now to the statements.
Okay, we're
or
going to turn
interviews
now
from January.
to Miss Love. Absolutely.
That finishes our business today, man.
You don't want to stick around? Okay. Well, okay. Thank you, Mr.
Okay, so
Banks.
here's all the judges for Bumpus.
At all? Okay. All right.
Look at all
okay.
of them.
Yes, you may be excused, sir.
That's a lot of lawyers she brought in with her. Okay. So then they take a break. This is all just today, guys. Okay. Now, first, notice Love's haircut. And I don't know what she was doing there. But second, notice that white dude has been put between Love and Hilton. I noticed yesterday Love wasn't in there much, but her empty seat was here. So they're putting space between Hilton and Love. And I'm guessing Hilton's doing that because I'm guessing she wants to stab Love in the eye.
Things
Now,
that we
just
think
watch
need to
Miss
be
Love.
redacted. That
It doesn't even matter what this man says. Just watch Miss Love and how this goes. Now, you guys know I love Shard, Attorney Shard. But just watch Miss Love's expressions.
we've converted our files to MP3. They're still going off the evidence reviewer. So we're working off two different transcripts and two different videos with different timestamps. So we've figured out a system to try to make it work. It's just a little bit time consuming. So we're working on it. We have identified, and we're going to get to the state what our proposed redactions are, and we still have to cross-reference their redactions. So it's just a time-consuming process.
Okay.
We're working as quickly as we can.
If they have redactions that they have identified at this point and they would like to turn them over so we can review them, and if they turn over both the transcript that they are using and the MP3 file that they are using that corresponds with the redactions that they've requested, we could review those. We could at least be reviewing those while they're correlating the ones we've given them to the media that they have and the transcript.
She makes me mad when she speaks, you guys. I get so irritated. Ugh. Always happy. Thank you so much for the $10 super chat. I appreciate it. I appreciate all of you who are supporting me. And I understand if you don't want me to teach your children how to curse, but know that if you ever leave your children around me, they will know how to curse when I'm done. When you come pick them up, they're gonna be like, Mom, that was some fucking bullshit. But they're going to say it right, damn it. Okay, so I don't know why Miss Love is talking. I don't know why she chose this new haircut. I don't know.
So that the downtime isn't a total wash, and we'll be able to make some kind of progress.
Sure.
I will see if we have.
Just watch her. Look at her eyes. Look at her. Look at Miss Love. Just watch Miss Love.
We'll figure out a way to get them the information so they can reference their materials so they can see what we're suggesting.
Okay.
And we can literally listen to it in their media format, however they give it to us, and we can know whether we agree or disagree in the format that they have right now.
Okay. So how much longer we all need?
Well, we are nearing the end of the January 28th statement. I don't anticipate the February 21st will take us quite as long. I anticipate the June 10th will be very lengthy.
Miss Perfect, I'd be happy to teach your child a cursing
so
course.
if you're asking to address
Highly
those
qualified.
two statements, I think that we could be ready in probably 45 minutes from now. But regarding June 10th,
Okay, well, let's just bifurcate it. As you all told me before, the June 10th one would be.
Look at her
would take
face.
the
Look at her
longest,
face.
so-
Look at her face. Did you see that? Did you see that look? Y'all. Look at her face. Watch her face.
what our proposed redactions are, and we still have
Watch
to,
Miss
but we
Love's
still
face.
have to cross-reference their redactions. So it's just a time-consuming process.
Okay.
We're
Look at
working
her.
as quickly as we can.
If they have redactions that they have identified at this point, and they would like
Did I
to
go back
turn
too
them
far?
over so we can review
I do that
them,
all the
and if
time.
they turn over both the transcript that they are using.
Just watch her face, y'all. Look at her. Look at her face.
I will see if we have.
Okay. Look at her. Did you see that look? Did you see that look?
But we'll figure out a way to.
Did y'all see that
We'll
look?
figure out a way to get them the
Jiggy, I don't know why Miss Love got this haircut. What does it mean when a woman changes her hairstyle abruptly? Are women supposed to notify the public before we change our hair? Like, I'm considering changing my hair, and we need to let you know for like months at a time before we do it. Because we don't know that's abrupt. Maybe she's been wanting it shorter for years. I mean, we don't know that. Yeah, Mr. Fierce, her voice is super annoying. It's part of the reason I have them on super quiet. I just want you guys to watch her facial expressions with her coworkers. Just watch her right now. Hey, Paradox.
I don't anticipate
Hi,
that
James.
February 21st will take us quite as long. I anticipate that June 10th will be very lengthy.
Okay, look at her. Look at her. Look at her.
So,
She's talking to the
if
white
you're
dude.
asking to address
And now
those two
he's going
statements,
over talking to Miss
we
Hilton.
could be ready in
So now we got a game of telephone going. We have a whole person between Hilton and Love. Look at Miss Love taking notes. She just whispered to the dude. She's now taking a note. Look at her stink face. Look at the look. 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 Did y'all see those looks? Did y'all see those looks? Oh, hell no. What we're not gonna do is come to court and be like my coworker and look at me like that. Oh, no. Let me go to, I'm gonna try to find Thursday, the green suit. I'm telling you, on Green Suit Day, Love was out of control. There was this whole section of Green Suit Day where Love was, she was reaching for the microphone and Hilton practically like hit it out of her hands. See if I can find it while I'm talking to you guys. I swear it was crazy. Like, Miss Love is out of control. And now, like, more than once, lawyers have made motions to ask the judge to stop Miss Love from making her ridiculous faces. I have never, ever, now, mind you, remember, I made a confession earlier on this day that I am quite dramatic, right?
The next question.
I made that confession. Y'all didn't know that beforehand. You could have never guessed. I am pretty dramatic. As dramatic as I am, I have never, ever had a judge had to ask me to stop making dramatic faces. I've never had someone say, hey, could you stop being so facially expressive in court? Because it's ridiculous.
Yes, okay.
Thank you.
Because it's ridiculous.
Mr.
And Miss Love is his,
Senior.
Willie says RICO happened to her hair.
Our motion for mistrials based upon the sworn
Y'all
testimony.
have
that
like
has
the
already
best
come out
comments,
from-
dude. I love it. Like, Miss Love is an ex-judge. Of all people who is aware that you're just supposed to sit there and not make expressions and just listen quietly without all the time. She's sure as hell quite expressive. She is quite expressive. All right, this was on day 91. We didn't get to talk about this because they came back on Friday, so we Just watch her face.
Quay was there back
Her
in
faces are
2015,
just,
so that's
oof.
the first point. He did not know Mr. Hughes.
And she should know better. Of all people in that courtroom who should know better, it's her.
Secondly, Your Honor,
I'd be irritated if I was
places
Hilton
my-
right now. I'm
it's a
trying to listen to this
bad
man's
faith
argument,
question.
lady. Quit talking to me.
It places
Look at her
Mr.
talking to her.
Hughes',
Quit talking to me.
Character in issue.
Hilton has to listen to this argument so she can
there's no
respond, and yet
basis-
she's
there's
having to
just
listen to
no
love.
basis for that question to be asked. And because of those reasons, Your Honor, we would respectfully ask this court
Look at
to
her
grant
face.
a mistrial as it relates to Mr. Huey based upon those natures.
Hilton's
There's just
just
no
like,
good basis
oh my
for
God.
that question.
Well,
to
I'm
be
guessing
asked
Hilton
when
was crying
the witness
because
had
of love.
testified on yesterday,
You
not
know,
to be repetitive, but he
the other day
testified
when
that
Hilton
he
was
didn't know that
crying.
guy in 2015. So how could he have been there in 2015 or
Let me
would
see if
he
I can
show
find
up
the
there,
part where this
at
this
the
woman,
interview with detective?
she was just like grabbing for the mic.
That is my point.
That's your
Hilton had to
assertion,
stop
sir,
her.
as a lawyer.
Man,
okay?
they've been
And
taking, like, the
maybe your
longest breaks,
frustration
too.
with,
You know, the
with-
judge is
with
upset, like,
everything.
oh, this
told you,
trial's taking
trial's
forever,
not a
and then he
long
takes
time.
an hour and a half, 10-minute break.
I know it been shut.
I've never seen someone need a comfort break for so damn long in my life. It's crazy. See if I can find it.
I believe my last question was,
How happy has Hilton been that yesterday all she had to do was play videos? Man, that was like her best day in court. She's like, thank God, I don't have to be made a fool of out of with this kid anymore. I just get to watch videos. Which I'm going to do a video about impeachment. I don't think her watching the videos or playing the videos is proper impeachment. So we will do a video about that, and we'll discuss what that looks like. And of course I can't find it. Damn. Well, I promise you it was there, y'all. I promise you that Miss Love reached for that microphone across Miss Hilton several times. Several times. Oh, I just passed it. All right. Well, you guys saw it. You know what I'm talking about. You know how bad Miss Hilton is. You don't need to see it. You already know. You already know. Miss Perfect, please email me. Feel free. The email is in the details. Or my email is in the description of this video, as is the Cashapp and many other ways you can get a hold of us. You can make an appointment if you need a consultation. I haven't done my introduction in hours. I'm lcadilac, and I am an attorney in Dallas, Texas. I am a civil attorney. I litigate. I am in the courtroom. I do not do criminal defense, but I do love watching other trials, and I came to this one because I was particularly interested in the First Amendment issues in using lyrics against someone. And then it has just been an absolute train wreck. It has been a pleasure to watch. And of course, every Friday at 10 a.m., I do a live recap. And then whenever there's downtime, I do bonus material like this. So, Sanyo says Hilton ain't trying to lose her license. She's not. And quite frankly, no one's going to lose their license behind any of this. They might get a slap on the wrist. They might get some kind of bar grievance, maybe a fine. But nobody's license is going to be lost. Usually the bar is only taking your license if you're taking money. You steal from people, you lose your license. And that makes sense, right? You do real shady shit. The 4 or 5 things Miss Love's done that are shady, or all the things that Miss Love's done that are shady, are probably still not going to get her license taken away. So, yeah. Okay, Gary says you can use the left and right arrow keys to scrub 5 seconds forward or back on the video. I'm going to have to learn how to do that, Gary. Do you mean like the arrow keys on my keyboard? Help me. I mean, I'm doing better, y'all. If you have been here for months, if you've been here for the whole length of the trial with me, then you are aware we have vastly upgraded. And it's been thanks to you. Now that we're able to get our super chats, and we have Cashapp donations, and we are able to get funds off of the channel, we've been able to upgrade the computer, so we're using a better computer. We finally downloaded the mic app. We figured out how to use that. So we are getting better. We're doing research on better cameras. We're doing better. And the more you support us, the better we can do. So I really appreciate all of you. I appreciate all of your support, all of your likes, all of your subscribes, all of your Cash App donations, all of your everything. You guys are the bomb. I really appreciate. Oh, quite a few people have brought up the judge eating today. It's gross, but it's like, it is his courtroom, you know, so he can do whatever he wants. You know, there are people who are streamers or whatever on YouTube and they like eat in their videos. I think that's gross too. And I'm only going to be eating in my video when I have, you know, just the screen where you can't see me, right? Like, I don't want you to see me eat. So I won't do that. But we know this judge doesn't have manners. He's not worried about that. You know, his mom must have passed away is my guess, because if my son were a judge and I saw him eating on TV, I would call him and tell him to cut that shit out. So, let's see. Someone says the white guy, Tanika says the white guy in the middle looks like the bad doctor from Phineas and Ferb. Hilton focuses on SVU. Oh, Lamar says she's usually SVU, and it shows. That's interesting, yeah. SVU cases are very different, and very different mannerisms in the courtroom and different approach, so. Raz says no way the jury will find Thug guilty. At this point, there's no way the state has proven beyond a reasonable doubt. Oh, and let me get into beyond a reasonable doubt. I'll go into that real quick, and then you know, hopefully they come back. If they don't, we'll all head home. Okay, so the thing with beyond a reasonable doubt. Okay, first I want to tell you a great place to kind of see beyond a reasonable doubt acted out is this movie. It's called 12 Angry Men. It has Henry Fonda. I think Henry was the dad. Anyhow, it's Jane Fonda's dad is in it, okay? And he was a good-looking guy back in the day. It is a black and white movie. Personally, I prefer color, but, you know, it's a good movie. So it's 12 Angry Men because they're a jury of 12. And so it's about a trial, and it's about the jurors. And they do some analysis after the presentation of information, and it is really an interesting movie and a great way to kind of get a grip on what beyond a reasonable doubt is. All right, so first, what is reasonable doubt, right? Okay, so let's give an example of things that are reasonable. I actually was on a stream on Saturday, and this lawyer gave these examples. He said, if your child comes in soaking wet and you look outside and all of the outside is wet, and the child says, well, I got wet because it rained. That's reasonable. You look outside, it's all wet. You know, maybe they did get wet in the rain. Reasonable. If the child comes in, they're all wet, and they say, well, I got into the hose. And, you see maybe the hose is loose. Oh, that's reasonable. But if your child comes in and they're soaking wet, and they say, yeah, an elephant was outside, and an elephant filled its trunk with water, and it splashed me down. That's not very reasonable, is it? That's not reasonable at all, in fact. I don't think. Okay, I heard they're back. Here we go. They are back. So let's get back into it.
Having a list of where we disagree. For that one statement.
We can cover this, Michelle.
Okay. All right. Well, I would just advise you all, unless there's disagreements to the contrary, to continue working on those other, I think, 16 and 15, 16, 17?
16 and 17.
All right.
I recognize that voice.
Eerily similar, eerily. Okay. And let's, let me touch base with you at 5 o'clock.
Okay.
I've got to decide a couple of things. One, I mean, we're off tomorrow, all right? But Thursday, if you're not done with these particular edits, whether or not we need to bring in our jurors for Thursday. Because you still have the edits for the 21st and you have edits for the 10th of June. And so we may end up having to work the next several days to get those done.
Understood.
Maybe the weekend.
As I've said,
So, I mean, because we need to get them done before I can probably listen to the, before they can be, because I need to rule upon them, and then, you know, it makes no sense to bring our jurors back in until such time as that occurs. Because you're looking at about 16 hours worth of stuff to include, and we hadn't even talked about this 2.5 hours of jail calls.
Your Honor, if to assist with the jail calls, we do have a jump drive. If the court wants to listen to the jail calls so that all we have to do is argument, to make that portion a little quicker, we do have a copy of the jail calls. The court, I think, has a copy with the jump drive that we served on but the jump drive with the drop box that we provided to defense counsel. It has the jail calls, but we also have just a quicker medium if the court wants to be able to listen to those, so we can just have argument at the
Let's get
right
through
time.
the first three interviews to begin with. The 28th of January, the 21st of February, and the 10th of June. Before I worry about the jail calls.
Okay.
so state what we're going to try to do is finish this, and then we'll try to get you a list of proposed redactions for the 21st.
That works.
Because Thursday, what I could, depending upon where you all are at 5 o'clock, what I could do is just, I could maybe take some argument on Thursday. Since if those edits are, I mean, if they're, you can tell me or flag which parts you disagree, and we can have argument. I can listen to them and we can have argument on those. Does that work for everybody?
Yes.
Okay, all right. So let me check back with you all 5, and we'll see where we are, okay?
Thank you.
Okay, all right.
Sorry, guys. I realigned my mic. Sorry about that. So I was just complaining about when I disagree with another lawyer, like on this. They have come to agreements on pieces of the evidence, but they have disagreements. I think they said on like 16 or 10 pieces, right? And so then you go into the courtroom and you say, okay, you know, here's what our disagreement is, and the judge says, oh, well, go talk about it. Well, buddy, if we were able to talk our way into an agreement, we wouldn't be standing here in front of you. If having a discussion about it was going to conclude the problem, we wouldn't have had to come in front of you. Hello? Oh, God, that shit drives me nuts. Oh my God. Yeah, sorry you missed that rant, man. I'm sorry, but God, that makes me crazy. I feel so bad for every single lawyer in this courthouse. And did you see that how easy it was to for Shard and Hilton to agree on something? They just said, you know, hey, da-da-da, boom. Oh, okay, we made an agreement. Boom. She's like, oh, that's okay. Do you notice it wasn't a huge argument over everything? Ridiculous. This judge just does not want to work, y'all. No jury on Thursday either. So they're off tomorrow for Juneteenth. No jury on Thursday, just arguments. So I'm going to come back on Thursday, guys, and we're going to talk about impeachment. Since they're not actually going to be doing any real work, we'll get through their arguments. If I have a free day, if I have a clear enough calendar on Thursday, I'm going to talk to you about impeachment. Oh, man, it is just ridiculous. Okay, so let me get back to reasonable doubt. Clifton said that it depends on where you are. Maybe it would be reasonable for your children to say, I'm soaking wet because an elephant just wet me if you were in Africa. But alas, Clifton, I am not in Africa. I am in Dallas, Texas. So it is completely unreasonable to believe that an elephant came and hosed down my children. And yes, Tim Mays was the name of the attorney. If you're in Atlanta and you need a defense attorney, he seems like a good guy. I met him on Saturday and I liked him. Okay, so that's reasonable, right? We just talked about reasonable. It would be reasonable to believe the child got wet from the rain. It would be reasonable to believe it was the hose. If you're in Phoenix, it'd be reasonable to believe the kid hopped in the pool, right? Like all of those things are reasonable. The elephant is unreasonable. Okay, so now you have to get beyond a reasonable doubt. So we know what reasonable is. We know what doubt is. All right, so if we're presented evidence and we go into the jury room and we're looking at the evidence and let me give you a great example. Karen Reed. Let's say we're the jurors of the Karen Reed trial. If any of you know about it, you caught up with it, you've been catching up with it. Karen Reed's defense is that she was framed. Okay? Her defense is that since all of the people of the house were cops and everyone's a cop and they're all cops, they all framed her and made it look like she murdered her cop boyfriend, when in reality it was the people who lived in and owned the house and all the other cops. Okay. Now, in the Karen Reed, I did see that there is in fact a deleted search from one of the people who owns the house that is like, how long to die in the cold. And that search happens at 2:30 a.m., which is 4 hours before Karen Reed shows up and says, oh my God, my dude is missing. If I'm in that jury room and I'm talking to the jurors about the evidence and I'm like, what about that deleted message? What about it is reasonable to be doubtful because I saw evidence of a deleted message. That creates a reasonable doubt. You know, there is a chance that it wasn't Karen. There is a chance that this other person, this other thing happened. There is a chance that this woman who deleted her searches is involved. Those are reasonable doubts. Now they have to get beyond that. That is a high threshold. It's a high threshold. And I feel like if more jurors actually understood the threshold that is beyond a reasonable doubt, there'd be less people in jail. I really do. I really believe that if people understood reasonable doubt, if they actually understood reasonable and doubt and what it means to get beyond that. So I saw a trial a long time ago. Sorry guys, I'm like, ooh, it's so hot. My sisters, oh, you can't, can you not hear me again? It says that it's working. Is it working? Can you hear me? Shit. Sorry, guys. Okay. I mean, I can hear. Can you hear me? Okay, so okay, good. Beyond a reasonable doubt. Okay, so I saw this trial once. I was like maybe, I'm gonna say 6th, 7th grade. So I'm like 12, 13 years, okay? 13 years old. My sisters, they're younger than me. They are identical twins. So what that means is there was one egg and then it split and created 2 humans. So one fertilized egg split into 2 humans. They have 99.999% the same DNA. They have different fingerprints, okay? But 99.99% the same DNA. So I saw this trial where these identical twins were on trial for murder, okay? Identical twins were on trial for murder. Whoever committed the murder wore gloves, so there's no fingerprints, okay? So if you're an identical twin and your DNA is found at a murder scene, there's no way, unless there's video footage and you have like different color hair than your twin or something, like maybe your head's shaved and your twin has long hair or something, there is no way anyone can prove beyond a reasonable doubt it was you, because you can get your genetically identical twin up there on the stand as a witness to create reasonable doubt. How can you prove beyond a reasonable doubt when you got identical twins and no fingerprints? And y'all, I saw that and I was like, my sisters are so damn lucky. That's what I thought. And then one of those dumbass sisters went on that 23andMe and put all our DNA in the damn internet, and so now no one in my whole family can commit any kind of crime at all. It's exhausting. Anyhow, it is fascinating. No, this is not the Mendez brothers, Hero Fix. The Mendez brothers are in prison. They are in jail. Shannon, if you can't hear me, I don't know why that's on you. I don't know. My sound appears to be working. No, these were twin girls. They were Asian and they were in their early 20s. And one of them killed the other, one of them killed a boyfriend. And it's either the sister killed her sister's boyfriend or the person with the boyfriend killed her own boyfriend. But you could not prosecute them beyond a reasonable doubt because you absolutely, genetically, with the DNA, could not tell the difference between the two. Can't prove beyond a reasonable doubt. It's not even worth trying with the prosecution in that one. Beyond a reasonable doubt is an incredibly high burden. My burden is in civil court is more likely than not. That's not that hard. More likely than not is a really low burden in comparison to beyond a reasonable doubt. Okay? So beyond a reasonable doubt is an incredibly high standard, and if more of us understood it, less of us would be in jail. That is my opinion. Okay. All right, guys. It is 3 o'clock Central. It is 4 o'clock Eastern. If they come back this afternoon to this trial, they're just going to come back to talk about when they start on Thursday. So, Jen Hahn. Okay, thank you always. I never went back to like look it up to see, you know, like what had happened or who it was. I just remember hearing about it when I was really young, and I remember being irritated that my sisters were twins. So they could never go to prison. That's all I remember about it. I was really young when that happened. So I feel like that was like maybe not even post OJ. I think maybe it was like pre OJ. Like it was a long time ago. I was very young. So okay. Nomenclature. Is it reasonable that Bort shot and Melly got out of the car and took off walking? Nomenclature, don't get me started on the Melly trial. All right? Don't even get me started. I watched that start to finish. It was not a shock or surprise at all in the least bit to me that went to mistrial. Not mistrial. Sorry, there was a hung jury. Not at all surprised on that one. All right, I'll be back for sure on Friday morning. Hopefully Thursday I can make it. It's questionable though. I have to do a bunch of work on a case that's pretty important. So I will try to come see you Thursday afternoon. If I am able to do that, we'll talk about impeachment. We'll talk about how an impeachment works. We'll talk about what impeachment actually looks like usually. And then we will see you on Friday for our typical recap at 10 a.m. Central. And then I'll see you again next week if the trial's still going. August 13th, I'm going to be in Atlanta. I hope to see you there. If there is trial, we'll meet at the trial at the courthouse at just after noon. If there is not trial, then we will meet at the meet and greet. And I hope that y'all can make it. And I would love to see all of you there. I appreciate everybody, your like, your subscribes, everything, 100%, all of your support. I appreciate you so, so much. Thank you. I hope all of you have a wonderful day, and I will hopefully see you Thursday, but I will certainly see y'all on Friday. Thank you.